Here is the reading of the third part of the Minnesota Supreme Court opinion, which let stand gender quotas for endorsements in Minnesota general elections for federal office to put people like Betty McCollum on the ballot by a majority of women DFLers endorsing her at every level, but not a majority of true DFLers. That is fraud. Secondly, they let stand an action which allowed DFL Secretary of State Mark Ritchie to exercise explicit discretion, emails collected under HAVA, the Help America Voters Act, whether he would release those two candidates for use, as has always been the practice of the Secretary of State's office. And thirdly, the Supreme Court allowed this to stand while blocking an election contest for Congress, which is required by state and federal law and judicial precedent. We reach a different conclusion with respect to Carlson's third claim, alleging that the district court improperly prevented him from filing an election contest. Carlson first asserted this claim 16 days after the district court refused to accept his election contest filing. Carlson had no known right to assert until his filing was refused on December 5, 2012, and that was actually December 4th. Given the nature of this claim, we cannot conclude that Carlson's 16-day delay to research and prepare his petition based on this claim was unreasonable. Because we have concluded that Carlson unreasonably delayed pursuing the first and second claims in the petition, our laches analysis requires that we consider the prejudice, if any, that would result if we granted relief on these claims. Citing Winters, laches prevents one who has not been diligent from recovering at the expense of one who has been prejudiced by the delay. Carlson seeks a wide range of relief in these claims, from a declaration of the unconstitutionality of Minnesota Statutes 202A.16 Subdivision 2, to an order directing the DFL party to amend its constitution, to an order invalidating Representative McCollum's election. Each of these remedies would disrupt the orderly administration of elections. Carlson's request to vacate an election for which he concedes the vote count was accurate is unprecedented and would inflict substantial prejudice on Representative McCollum, the voters, state election officials, and the United States House of Representatives. Given petitioner's unreasonable delay and balanced against the significant potential prejudice to respondents, to other election officials, to the candidate, and potentially to other candidates, and to the electorate, we conclude that it would be inequitable to grant the relief sought. Given Carlson's unreasonable delay, and in light of the substantial prejudice to the orderly administration of elections, it would be inequitable to excuse Carlson's delay and grant him relief on the first two claims of this petition. We therefore hold that laches bars the first two claims in Carlson's petition, and we dismiss these claims. But because we conclude that laches does not bar Carlson's challenge to the district court's refusal to accept his election contest for filing, we next consider whether that claim is properly asserted in a petition invoking this court's jurisdiction under Minnesota Statutes 204B.44. Minnesota Statutes 204B.44 authorizes proceedings that seek to correct, quote, errors, omissions, or wrongful acts, unquote, particularly with respect to election ballots. The, quote, principal purpose, unquote, of this statutory remedy, quote, is to provide a mechanism for correcting errors alleged to have occurred before the election, such as in preparing or printing the official ballot. And that's from Coleman versus Ritchie, Minnesota 2009, in which the lead attorney for the DFL and Al Franken was, in fact, David Lillehaug. David Lillehaug is now writing this opinion because Mark Dayton, fellow DFLer, put him on the Supreme Court after this petition was filed. So he walks in and he writes the opinion on this matter. Carlson asserts that his challenge to the district court's refusal to file an election contest falls under paragraph D of this statute. And by the way, paragraph D is not the one that Lillehaug wrote that talks about counting ballots. That is a different paragraph which I'm not using. It's a different subparagraph which I'm not using, which permits a challenge to a wrongful act, omission, or error of any other individual charged with any duty concerning an election. That is from the statute 204B.44D. That is what this is brought under, and which the Dayton Court ignored in order to defend unconstitutional quotas and unconstitutional manipulation of email addresses collected by the state. This is the party that accuses Michelle Bachmann of manipulating email addresses collected by the state in Iowa, but which claims explicit discretion to do whatever they wish in terms of releasing the email addresses they have collected throughout the state of Minnesota. We disagree. The duty about which Carlson complains in his third claim in the petition is not one concerning an election. The duty about which Carlson complains is the district court's duty to accept his election contest filing. But the obligation of the district court to accept court filings cannot be converted into a duty concerning an election simply because the underlying filing that was not accepted is an election contest. This is so because 204B.44 is not a broad vehicle through which any conduct with relationship to an election, however tangential, can be challenged. And this is from the case Minnesota Majority versus Ritchie. This was also in 2009 when the chief elections attorney was David Lillehaug, who now writes this very incorrect and highly dangerous opinion. To the contrary, our precedent recognizes that Section 204B.44, quote, provides a remedial process only for correction of the ballot and directly related election procedures. Carlson's challenge to the district court's refusal to file his Chapter 209 election contest does not fit within the narrow parameters we have recognized as within the scope of Section 204B.44, and we therefore dismiss this claim. An election contest under Chapter 209 with respect to a congressional race decides only, quote, which party to the contest received the highest number of votes legally cast at the election and is therefore entitled to receive the certificate of election. That's Minnesota Statutes 209.12. However, judicial precedent has established that no Minnesota court, including the Minnesota Supreme Court, whether or not headed by a DFL election attorney, David Lillehaug, no court has jurisdiction to reach any findings of fact or conclusions of law. All they are allowed to do is collect that evidence and forward it to the U.S. House of Representatives. And this, the entire DFL party, including the governor, and now David Lillehaug, and the entire Minnesota Supreme Court are blocking. And they're using the device of a decision made in the District Court of Ramsey County. As noted in his election contest filing, Carlson does not dispute the vote count for the election in the 4th Congressional District. Because we dismiss his claim as outside the scope of Minnesota Statutes 204B.44, we do not decide whether a petition that does not contest which candidate received the higher number of votes can nonetheless be brought simply for the purpose of taking, quote, evidence on any other points specified in the notice of contest, including deliberate, serious, and material violations of the Minnesota election law. That's from Minnesota Statutes 209.12. In other words, this Dayton Minnesota Supreme Court defies the state law, defies judicial precedent, and defies the absolute jurisdiction and authority of the U.S. House of Representatives. And as I will set forth in my U.S. Supreme Court petition to overturn this badly decided or undecided case by the Minnesota Supreme Court. Minnesota is allowed by the United States Constitution autonomy in conducting federal elections, but that autonomy extends only to obeying the United States Constitution, which their conduct violates, and further to following their own state laws that they set out. And in this case, following the judicial precedent, which does not give to the Minnesota Supreme Court any authority not to take this evidence that was set forth in an election contest and give it to the U.S. House of Representatives. This will also be given to the U.S. House of Representatives. This evidence, which will also be given to the United States Supreme Court. And I strongly urge that the Minnesota Supreme Court and Governor Dayton reconsider what they are doing, because they are blocking free, fair, and democratic elections in the state of Minnesota in violation of our admission to the United States of America as a state.